We can start. I'm Jan Jordaan. I'm going to be the presenter and speaker today. I'm going to share with you a PowerPoint presentation just now. And then let's start with that then. Okay, share screen. There we are. Can everybody see the screen? Okay, so what we're going to discuss today is it's aimed at educating first-time home buyers. Before we get to that, just house rules. Please mute yourself to make sure that there's not a noise in the background. And then if you do have questions, you can ask it in the question little block, or afterwards you can unmute yourself and ask questions. Hope that's okay with everybody. All right, as I said, I'm Jan Jordaan. We're going to discuss first-time home buyers to see if we can help people that if they want to buy a new house, what they should look out for and how we can help you when we get to that point. All right. As I said, I'm Jan Jordaan, director of Jan L Jordaan Inc. There you can see our telephone number. info@janljordaan.co.za is our email address and our website. Please people, this presentation is recorded, so if you want a copy of this, you're welcome just to request a copy of it. We are specialists in the administration of deceased estates, property transfers. We do wills at no charge, transfers of properties, and that's basically what we're going to discuss today. We're doing registration of bonds. We're also doing cancellation of bonds, and we're on the panel of ABSA, FNB, Nedbank, and Standard Bank. We do antenuptial contracts, and we do trusts. And this year we are celebrating our 30th anniversary in practice. All right, purchasing a property, the process, very important, is first to find out what amount you can qualify for. So I'm going to jump around between the slides, but the first one is first find out what amount you qualify for. Before we get to that, you know, if you buy a property or if there's a property available on the market for, let's say, 1.5 million, it actually means nothing. You're more interested in knowing what your monthly expenses will be. So it's so important that you know what you can afford and what you can't afford. So let's have a look at that quickly. Find out what amount you qualify for. Now, this is a rates card that we use. On the left-hand side, you'll see there it says the amount, and then it starts at 500,000, it goes through to 2.2 million, and then on the right-hand side of the page, it carries on with 2.3, etc. That's the purchase price if you're interested in knowing what the cost will be. So let's take an example of 1.5 million. If you would buy a house for 1.5 million, remember there will always be transfer cost as well as bond cost. On 1.5, it will cost you 53,500, and the bond cost will be 36,497 rand. Now, before I carry on with that and explain the rest of this, the 53,000 will include all the disbursements, the cost to transfer. That means a transfer duty, which we'll discuss just now. Our fees, the attorney's fees, deeds office fees, everything is included in that. When it comes to the bond, you must understand that if you buy a property for 1.5 million, and let's say you put down a bond, a deposit of 500,000, then you're going to look at what the bond will cost you on R1 million. So in this case, it is 30,274. So the point I'm making here is your transfer cost is calculated on the purchase price. Your bond cost is calculated on whatever the bond amount is. Okay. Now let's go back to 1.5 million. This is what it will cost you per month. And that's what I said that's so important. If you buy a property for 1.5 million, it actually means nothing until you actually know what it will cost you per month. So a bond of 1.5 million will cost you 15,000 rand, And now this last column, I can't emphasize it enough. This is just a guideline. Income to qualify for a bond. Only a guideline. At the bottom, the 4 stars, you'll see income to qualify for bond. Please consult your bank, your estate agent, financial advisor, bond originator with regards to National Credit Act. But this is a fairly good indication of what you will qualify. All right, so for 1.5 million, you need to earn about 45,000 Rand to be able to afford that. All right, I hope that it's clear. So let's go back to the second point. Find a suitable property you like. There's so many places you can look. You can contact your local estate agents. I mean, they advertise everywhere. You will see that they've got their boards outside houses that's for sale. You can contact them. You can Google properties that's for sale. You can go to show houses. Normally, as a rule, it's on a Sunday afternoon. Do yourself a favor and go and look and find out what the values of those houses is, and then you'll get a good indication what you can afford and what you can't afford. Then there's websites like Property 24 and Private Property that you can also visit and look for a property. Now, here's a very important point, people. Please note this. When you make an offer and that gets accepted by the seller, there's a legal binding agreement. We often get clients and say, but they didn't know that they were actually making an offer. They thought they were just completing a form. But the moment you make an offer and the seller accepts it, then there is a legal binding agreement. So make sure that you know what you're signing, because that the seller can keep you to whatever's agreed in that agreement. All right, so let's see. We've discussed it. Next slide, I say, if you want a copy of this rates card, please email and request a copy from Charlene at janljordaan.co.za, and she will gladly send you a copy of the rates card. But one better, if you go to our website, and please have a look, it's Jan L Jordaan Inc.co.za. Inc is incorporated. If you go into our website, on the right-hand corner, up in the corner, you will see there's cost calculator. You click on it. It's very, very user-friendly, very simple. You put in an amount in, and for the purchase price and for the bond, and you say submit, and it will give you a breakdown in detail of what the costs are. In other words, the attorney's fees, the deeds office fees, the transfer duty, everything will be in there. Okay, so the cost calculator is actually the way to go. Transfer duty versus VAT, we'll discuss that just now, but for your own knowledge, transfer duty is calculated as follows. If you look at where it says 0%, on the first R1 million, there is no transfer duty payable. But please don't get confused between transfer duty and transfer cost. There will always be transfer cost. In other words, the attorney's fees, because a professional needs to transfer the property into your name. But there won't be, there won't be any transfer duty for the first R1 million. It works on a sliding scale. So if you buy a property that's, let's say, between 1.5, let's say it's 1.5 million, then they calculate it on the first million at 0. Then 3% between the million and 1,375,000. And as I said in our example, 1.5, then it will be 6% on the amount between 1,500,000 minus the 1,375. That difference will be 6 million. And that's how your transfer duty is calculated. Remember, and then it carries on. If you buy a property that's more than 11 million, then it's at 13%. Remember, when you buy a property, make sure that you know if you're going to pay transfer duty or VAT. Now, if you're buying a residential property, I can assure you 99.95% the chances will be that you end up paying transfer duty and not VAT. But if it is VAT, then please remember that it's 15% of the purchase price. Okay. Now we're going to look at the agreement. I start off, and I've got it in bold. I say a contract is the foundation of any agreement. Now, I can't stress that enough. That agreement contains everything that you agree on. I made a little star there, and I refer to this paragraph. I just want to close this. Okay. This paragraph, in any standard agreement, you will get a paragraph like this. It says, this agreement constitutes the sole and entire agreement between the parties, and no warranties, representations, guarantees, or other terms and conditions of whatsoever nature not contained herein shall be of force or any force or effect. Before I carry on, so if the seller tells you whatever and it's not in writing, please understand it means nothing. It has to be in writing to mean anything. Okay, so you can't afterwards say, but Mr. Seller or Mr. Estate Agent, you said ABC. It doesn't work like that. It has to be in writing. And the second sentence, no variation of the terms and conditions of this agreement or consensual cancellation thereof shall be of any force or effect unless reduced to writing and signed by the parties or their duly authorized representatives. So people, the point I want to make is, the point I want to make is that your agreement is fundamental to a successful transaction. If there's anything that you think that's discussed, let's take a simple example. There's a pot plant at the main entrance, and the seller says, for instance, you can keep it. Make sure it's in the agreement, because if it's not in the agreement, he can take that pot plant, and so it goes for everything. A typical example is if there's a coffee bar or just a normal bar, and there are bar stools, and the seller says you can keep it. Make sure that it's in the agreement that you are allowed to keep it. All right. What makes a contract valid in South Africa? A sale agreement of a property has to be in writing. You cannot buy a property in South Africa verbally. Okay, so that's important. When it's in writing, it has to be signed by both the seller and the purchaser. Second point, the parties to a contract. I just mentioned that because you as the purchaser need to know you must decide beforehand in whose name you're going to buy it. Is it just your own name? Is it you and your spouse? Remember, if you're married in community of property, then you have to buy it in both people's name. If it's a company, then make sure that the company is registered, etc. Okay. Property description, make sure that it's properly described. Street address, sometimes properties are subdivided. I've seen it where the entrance is in a different street than the actual address of the property. So make sure that the address of the property is correct. If it's a sectional title, these typical block of flats, make sure it's properly described in the agreement. Now, the fourth point, the purchase price. People, please, you do not have to buy, or you do not have to pay a deposit to have a valid legal and binding agreement. It's a good thing to have a deposit, but you don't have to give or pay a deposit. Right. Now, I made it clear, I put it here in the notes, trust account versus interest-bearing account. Sorry, I see there's somebody trying to get in. John, are you there to allow Deveni Naidu in, please? So trust account versus interest-bearing account. When you pay money into the attorney's account, people, first of all, make 100% sure that you've got the correct account number. Hackers are a...
No. I always go on this webinar with the... Let me just make sure I'm mute. Oh.
Yeah. Thank you, Deveni.
Sorry.
Deveni, I hope I pronounced it correctly. Make sure that you pay it into the correct account number. Hackers are a reality in South Africa. And we've had it before where people paid into the wrong account because hackers hacked it and gave them the incorrect account. So do not pay money into an attorney's account unless you personally verified that account. Pick up the phone, phone them, and ask them what the account is and confirm that. Okay, let's get back to trust account versus interest-bearing account. When you pay money into a conveyancer stroke attorney's account, you always pay it into their trust account. A trust account is an account that any attorney that practices has to open. You're not allowed to practice if you don't have a trust account. The interest in that trust account has to be paid to the law society, all right, by law. But on your instruction, the attorney may move it to an interest-bearing account where you then entitled to the interest. Just to go back, if it's in the trust account, the law society has got insurance that should the attorney steal the money, then the law society will cover that money. But the moment you take it out of your trust account and you put an interest-bearing account, that security falls away. So if you want your attorney to put an interest-bearing account, make sure that he's got his own insurance in place. We, for instance, have got insurance up to 11 million rand per client that pays money into or transfer money into an interest-bearing account. All right, so very, very important. Then a bond, normally 99% of most of transfers or sales, it's subject to a bond. That means that you have to have a bond granted by a bank, and that's normally a suspensive condition. If you look at paragraph 5, the difference between a condition, a normal condition versus a suspensive condition. To start off with a suspensive condition, if you apply for a bond, it's normally a suspensive condition, whereby it would say this agreement is subject to the bond being granted. If the bond is not granted, then the agreement will be null and void. In other words, there is no agreement there. That's what a suspensive condition is. If it's a normal condition, then let's take an example. You're supposed to pay a deposit within 7 days of signature of the agreement, and you don't pay the deposit, then you are in breach, and then the seller has to put you on terms. And when I say on terms, he will have to send you a letter to say, Mrs. Purchaser, you have not complied with the conditions of the agreement. You are therefore in breach. And if you don't pay the deposit within 7 or 14 days, depends on the agreement, then as the seller, I can take further action. We'll have a look at that now in paragraph 8, or we can just discuss that. If you look at paragraph 8, so I put you on terms if I'm the seller, and you have to then come up with the money within that time period as per the agreement. If you're the seller, you've got two choices. You can say to your purchaser, I am going to apply, if you don't pay that money, I'm going to apply to court to force you. We refer to that as specific performance, and the court will make a court order that you have to proceed with the sale. Alternatively, I can say to you, if I'm the seller again, that I'm going to agree to the cancellation, or I'm going to cancel the agreement, but I'm going to sue you for damages. Okay, so get the difference between specific performance and claiming damages. All right. Now, occupation, I'm back to paragraph 6. Normally, in an agreement would agree that in a contract they will agree that occupation is on date of registration. That's normally how it works. So have a look at that in your agreement as well. Voetstoots clause. The voetstoots clause means that you sell a property as is, all right? But the voetstoots clause, or the as is paragraph, only protects a seller as far as the default is obvious or where he has declared the defect. Now, to use a simple example, if you say that when you walk into a property and there's no front door in the main entrance, and you make an offer on the property, you are then buying the property without a front door or without a door, because it's obvious there is no door. The seller doesn't have to disclose that because it's obvious. And that's what you're buying. However, if there's a defect and the seller is aware of it and he does not disclose that, then you as the purchaser has got the right to claim that from him, to refund you or to pay you or fix that. Now, typical example, the classic example is where a seller has got the house has got a leak in the geyser, and they took buckets and you put it under the geyser, and the geyser is then the water is dripping into the bucket, and he did not disclose that. Now, that's obviously that he knew about it, and he will then be liable to fix the geyser. Now, there's a new thing that came out in February last year. That's a mandatory disclosure form. Your seller has to, by law now, has to declare or disclose rather any defect. Now, I'm just going to read one or two of those paragraphs to make sure that you understand. Let's have a look at paragraph 1. Are you aware of any electrical faults / problems regarding the electrical installation or appliances? And if you say no, and there are, then obviously you as the purchaser are entitled to claim it or have it fixed by the seller. Let's look at number 10. Were any repairs done to the items specified in 9 above over the past 6 months? And it carries on like that. Okay, so your seller has to disclose any defects, and by having this mandatory disclosure form, that eliminates so many problems, because then there can't be any arguments after registration. Okay, so people, potential purchasers, this document is vitally important. By law, you have to sign this at the same time that you sign the agreement, or at least before you even sign the agreement. You need to know. You can't sign, if you sign the agreement and then 6 days later sign the mandatory disclosure form, I mean, it just doesn't make sense. Because if you buy the property and then only six days later they inform you about all the defects, can you imagine all the problems that's going to come from that? So your agent or whoever is dealing with the property or the contract has to disclose that to you, and you have to sign it. You see, there's the seller, there's the purchase, has to be signed by both parties. All right, so we checked, we've gone through paragraph 6, the occupation, foot stewards clause, the breach we've discussed. Transfer and bond cost, we touched on that. The point I want to make here is that please remember, if you're the purchaser, there will always be 3 attorneys involved. 2 of those attorneys will be relevant to you if you take out a bond. There will be a transfer attorney and there will be a bond attorney. Not necessarily the same attorney. However, it could be the same attorney. Okay, but there will be 2 separate accounts. We've had it so many times where people would say, but they didn't know that they're supposed to pay a transfer attorney and a bond attorney. It's 2 separate instructions with 2 different things that needs to be done, and therefore there will be 2 different accounts. The bond cancellation attorney, if the seller's got a bond, the seller will be then liable for that. Transfer duty, we touched on that, the sliding scale versus VAT, which is 15%. We have discussed that. Paragraph 11, fixtures and fittings. What is a fixture and when may it be removed? I go back to that very paragraph 1, that very first sentence after the heading of paragraph 1. A contract is the foundation of any agreement. Make sure that everything is covered in your agreement. I go back to my simple example. If there's a pot plant and it's discussed that you can get it, use the purchaser, make sure that they put it in the agreement. To find out what is fixtures and what is fittings, they say you should actually take the house turn it over, and whatever falls out, that is that's fittings. Whatever stays in the house or in the house, that will be fixtures. But people, I'm now repeating myself, but rather insist that your agent, if there's an agent involved, have everything that was discussed, that it's in the agreement to make sure that you are entitled to that. Electrical, paragraph 12, or point 12 rather, electrical and gas certificates of compliance. The seller by law has to issue electrical certificate if there's gas in the house. If they use gas stove, etc., then he has to issue a certificate as well. So an electrician, qualified electrician, or a qualified gas, I don't know what they call themselves, will come in, check everything. If anything needs to be fixed, they will fix it. Very important point, however, is that the appliance, let's say we talk about a stove, the electric compliance certificate is not going to cover any appliance. For instance, the stove, if the stove is not working, the electrician can still issue the electrical compliance certificate, because he only has to issue it to the point where it's used, not the appliance. So make sure you understand that point. All right, that's the agreement that we covered. Let's have, we've spoken about the mandatory disclosure form, which is part of the agreement. Insist on that. By law, it has to be. We looked at the foot stewards clause, or as is clause. Now we look at the role of an estate agent. I made a few notes here. Estate agent can potentially play a massive role in the success of a purchase of a property, for that matter, the sale of a property. If you make contact with your estate agent, and if they're sharp and they know what they're doing and they listen to what you want, they should be able to get you a property exactly what you want. Okay, so an estate agent can guide you and save you a lot of time. He can also assist you with the pricing of the property, where, you know, in a certain area, if you're interested in the property and it's overcapitalized, or whatever the case might be, the agent's got normally lots of experience and they can guide you nicely in there. The agent can also compare houses with other houses in the area. If a house is on the market for 1.5 million, he can tell you what other houses have been sold in that same area. You know, if you're interested in 1.5 and all the other houses are getting sold for 500,000, then you need to be careful. So ask your estate agent to guide you in that matter. The estate agent can also guide you in the process. They will know exactly, basically what I'm discussing here with you now, your estate agent can assist you with that. Also, an estate agent has got contacts and know people, bond originators. He can introduce you to certain bond originators that can assist you with to apply for a bond. Now, a bond originator is a person or company who's got agreements with all the different banks. They submit your application to different banks, and then the banks will make you an offer. So your estate agent can refer you to a good bond originator. The agent can also assist you with a negotiated date of occupation, and then normally they are present when the keys are handed over, so if there are any questions. So the estate agent potentially could play a huge role when you want to purchase a property. The role of an estate agent. I made a few notes here. Estate agent can potentially play a massive role in the success of a purchase of a property, for that matter, the sale of a property. If you make contact with your estate agent, and if they're sharp and they know what they're doing and they listen to what you want, they should be able to get you a property exactly what you want. Okay, so an estate agent can guide you and save you a lot of time. He can also assist you with the pricing of the property, where, in a certain area, if you're interested in the property and it's overcapitalized or whatever the case might be, the agent's got normally lots of experience and they can guide you nicely in there. The agent can also compare houses with other houses in the area. If a house is on the market for 1.5 million, he can tell you what other houses have been sold in that same area. If you're interested in 1.5 and all the other houses are getting sold for 500,000, then you need to be careful. So ask your estate agent to guide you in that matter. The estate agent can also guide you in the process. They will know exactly, basically what I'm discussing here with you now, your estate agent can assist you with it. Also, an estate agent has got contacts and know people, bond originators. He can introduce you to certain bond originators that can assist you with to apply for a bond. Now, a bond originator is a person or a company who's got agreements with all the different banks. They submit your application to different banks, and then the banks will make you an offer. So your estate agent can refer you to a good bond originator. The agent can also assist you with a negotiate the date of occupation, and then normally they are present when the keys are handed over, so if there are any questions. So the estate agent potentially could play a huge role when you want to purchase a property. The role of an estate agent. I made a few notes here. Estate agent can potentially play a massive role in the success of a purchase of a property, for that matter, the sale of a property. If you make contact with your estate agent, and if they're sharp and they know what they're doing and they listen to what you want, they should be able to get you a property exactly what you want. Okay, so an estate agent can guide you and save you a lot of time. Next one, when and where to apply for a bond. I say first, in terms of when to apply for a bond, see the conditions of the sale agreement. In brackets, I said normally it's 21 days after the signing of the agreement. Normally, if you have your own business, you don't draw a salary, then the agent will negotiate a 30-day period for you to get a bond. So that's the when. Where to apply? A bond originator, we touched on that now. They will assist you. The nice thing about them is they've got access to all the different banks, and you could potentially get offers from different banks. Alternatively, you can go to your own bank and apply for a bond via your local branch. Next one, when and where to apply for a bond. I say first, in terms of when to apply for a bond, see the conditions of the sale agreement. In brackets, I said normally it's 21 days after the signing of the agreement. Normally, if you have your own business, you don't draw a salary, then the agent will negotiate a 30-day period for you to get a bond. So that's the when. Where to apply? A bond originator, we touched on that now. They will assist you. The nice thing about them is they've got access to all the different banks, and you could potentially get offers from different banks. Alternatively, you can go to your own bank and apply for a bond via your local branch. Next one, when and where to apply for a bond. I say first, in terms of when to apply for a bond, see the conditions of the sale agreement. In brackets, I said normally it's 21 days after the signing of the agreement. Normally, if you have your own business, you don't draw a salary, then the agent will negotiate a 30-day period for you to. I say here, see the list of all the documents needed to apply for a bond. Now, I've got a list here for full-time employed. When you're full-time employed, self-employed, or building loans, I got this list from a bond originator. That's obviously not in our world. We don't really deal with it. That's where bond originators come in. We can quickly read through it. If you're full-time employed, the bond originator or the bank is going to ask you for a copy of the purchase of the offer to purchase of the agreement. There will be an application that you have to comply or complete, copy of your ID, latest 3 months bank statements. I see that specifically say non-internet printouts. So you'll have to go to your local branch and get a printout there. Proof of income and your latest payslip. Okay, so if you know you're going to buy a property, get these documents in place in the meantime. If you're self-employed, there's a little bit more. I'm not going to read through everything. I see it's 2 years consecutive financial statements. Your cash flow forecast for 12 months may be requested. And then the last point, latest 3 months personal and business statement. So there's different things that need to be provided when you are self-employed. The banks normally take a little bit longer. And that's why if you're self-employed and you apply for a bond, make sure that you negotiate at least 30 days to apply for a bond. The last one is a building loan. You can quickly run through that. The fully completed, sorry, let me just take, I can't see that. Fully completed building contract with the offer to purchase, tender and schedule of finishes, approved plans, NHBRC registration certificate, NHBRC enrollment certificate. Just to explain that, your builder has to be registered with the NHBRC, that's the National Home Building Regulation Council, and then he has to enroll that specific house or project with the NHBRC. And also a letter of good standing from the builder's accountant. Okay, so those are the forms that's needed if it's a building loan. Okay. The conveyancing process, and in other words, what happens in a conveyancer or an attorney's office. Just to explain the conveyancer or attorney, you cannot be a conveyancer. That's extra qualification unless you're an attorney. So you can't be, you have to be an attorney and then you become a conveyancer. It's an extra exam that you have to do, and then you're a conveyancer, and then you can attend to the transfers of properties. So the question is, what happens in the conveyancer's office when you buy a property, which I'll discuss now, and then also the deeds office. When we're ready and we've prepared all the documents, we take it to the deeds office, we submit our documents in the deeds office, and that's where it gets registered. So let's have a look at the next slide. So we prepared a slide here, the roadmap to the transfer process. In simple terms, or what we normally do is we give this handout out to clients and they can see the process. But in simple terms, the transfer attorney will get the instruction. He would then ask for cancellation figures. He will also send a letter to the attorneys who has been instructed to do the bond, and then ask guarantees from them. The bond attorneys will get this purchaser in to sign their documents. The bond attorneys will then give the seller or the transferring attorney guarantees. The attorney will then also apply for clearance certificates from the town council, because when you buy a property and it's registered in your name, then you must make sure that there is no outstanding debt with the town council. By the way, you can't transfer a property without a clearance certificate. Okay. We also have to pay the transfer duty. That's the amount that we discussed early on that we have to pay to the receiver of revenue. And then when we're ready, we put all the documents together. We make contact with the bond attorney, and we make contact with the bond cancellation attorney, and we all submit the documents to the deeds office. The deeds office would take between 8 and 10 days, which we'll discuss now on the next slide, before it comes up on prep, and then it gets registered. And when it's registered, it means you as the purchaser is then the new owner of that property. Okay, so that's a roadmap. and then also the roadmap in the deeds office. So the long and the short is it gets submitted to the deeds office. It goes to, if you look at number 4, a junior examiner. He will go through all the documents and check to see if everything is done properly. Then it goes to a senior examiner. He will also make sure that everything is fine, and then goes to a 3rd level, the assistant registrar. So your documents, our documents will be checked 3 times by the junior examiner, senior examiner, and the assistant registrar. If they are happy that everything is in place, they might make a note in the back of your file to say fix this or fix that, but they might also decide that the mistake that was made is of such a nature that it will be rejected. Then it will be thrown out of the deeds office, and your conveyancer will have to fix whatever needs to be fixed, and he will have to lodge it in the deeds office again. Now, I think it's important to understand that when it goes through the process, the documents then comes up on prep, as we call it. I think it comes from the word preparation. In fact, I know it comes from the word preparation. It means that it's been prepped by the deeds office. They will then ask the conveyancer to sign it off, to say that they're happy, they can proceed with registration. It gets finally black book. In other words, the deeds office will check to see if there's interdicts against the property or attachments against the property. Has anybody sued the owner for the property, etc.? And then the next day it will be registered. That's why it takes about 8 to 10 working days before it's registered. Okay, we're not going into detail with this, but if you want a recording, you can obviously work through this. Both these pages, if you want copies of that, the roadmap to transfer and the roadmap for the deeds office procedure can be obtained from Charlene, and I have given you her email address earlier on. All right, now, a very important point is the municipal account. You as the purchaser has got a responsibility that once the property is registered in your name, that you have to go to the local town council, the local authority, and go and pay your deposit at the town council, and then change the details of the property to your name. Now, how it works in practice is, once it's registered, we diarize our files for about 2 weeks. We then do a deed search. Now, deed search means we are linked with the deeds office. We go into the system, and the deed search will indicate that the property is registered in your name. Now, the deeds office takes a few days after registration to update their records. Therefore, that's why we wait about 2 weeks before we do that. We then send that proof to the purchaser and the seller. The seller has to go to the municipality, hand in the proof that that the property is not in his name anymore. The purchaser has to do the same and pay his deposit. Then the town council will amend the records and then send the purchaser the account. So people, I can't stress it enough, as a purchaser, after registration, after you received something as a proof from us that the property is registered in the purchaser's name and your name, that has to be taken to the town council to have it, to change the account at the municipality. The next, that's our story. If there are any questions, let's have a look quickly in the chat box, which I will see if I can answer. And then if I've done with that, then you're welcome to unmute yourself and ask questions. The first one is from Andrew. Hi, Jan. I bought a property 2.5 years ago and has a lot of rising dam. The seller did not declare this. I've had multiple builders say that this was present at the time of the purchase, but was covered by a fresh coat of paint just prior to the sale. The cost repair is 200,000. Can I claim this off the seller? Andrew, yes, you would be able, but it's going to be a point where you'll have to prove that it was there when you bought it. You will also have to prove that the seller must have been aware of that. Now, if you say to me, the builders and everybody that's trying to help you said to you that that's something that was covered up, then that will be your witnesses. And I think the chance of you being successful is very good. So the long and the short is, yes, Andrew, you can. All right, I don't see if there are any other questions. If you want to ask a question or unmute yourself and ask a question, you're more than welcome. All right, if there are no other questions, then...
sorry, Jan, Tarina has a question.
Just a moment.
Tira, sorry. Tahira, sorry. In the chat.
Just a moment. I'll be with you now. I just want to go back to the screen. Who wants to ask the question? Sorry.
Tahira has a question in the chat.
Tahira, in the chat box.
Yes. Hi, Jan. Please elaborate in the new procedure from the council on obtaining rates clearance figures.
Okay. Tahira, good question, because it's very relevant. We mainly work with Benoni, and they are brilliant. In Benoni, you submit it electronically. One of my ladies explained to me yesterday, she submitted it yesterday. They immediately, I think it was 10 minutes after that, they send the clearance figures, which the seller immediately paid, and we're expecting to have the clearance certificate today. However, for some other reason in Boksburg, Tahira, I'm not sure if you're involved in Boksburg, there's a major problem. I've sent one of our staff members, Kim, there today to go and see if they can sort something out. And if she can't sort it out today, I undertook to go personally there tomorrow to find out what the blockage is. And Boksburg is a major problem at this stage. I'm sure they will sort it out. But in Benoni, it's actually an absolute pleasure. Please elaborate on the new procedure. That's Tahira. Springs, unfortunately, Tahira, I don't have much experience there. I haven't heard any of my staff members complaining about it. So I would like to think that they also up to date and things are running smoothly there. At this stage, I'm just aware of Springs, Boksburg, that's a bit of an issue. All right. Any other questions? Okay, Tanya, do you see any other questions? Because I'm going up and down and I don't see anything.
No, I don't see anything else.
People, Jan, in Springs, there's a backlog at the moment. This comes from Elena. So, yeah, there you are. There's your answer, Tahira. It looks like in Springs, there's a bit of an issue as well. But, you know, people, I remember years ago, we had to pay transfer duty manually at SARS. And when they changed it to electronic payment, everybody was up in arms and unhappy and so forth. And we had teething problems in the beginning, but now it runs so smoothly. So, yeah, expect teething problems, expect backlogs at the moment, but it will work out. We just need to be patient. All right, if there are no other questions, then that will be the end of this webinar. Please remember to email Charlene if you want copies of that rates part, what we call it, and please visit our website and make use of the calculator. Thank you, everybody. Have a good day. Thanks for attending, and hopefully we'll chat soon.
So, sorry, Jan, just a quick one.
A question? Yes, sir.
If I want to follow up on that issue with the dam, what's the approach? Do I contact the seller directly, or do I go through the attorneys who process the deal?
My experience is that especially if it was a 2,000 problem, to approach the seller, that would have been easy to solve. 200,000, I don't know of a seller that will just take up 200,000 and pay you. Going to the conveyancer, a conveyancer is not geared and doesn't really do litigation. Depends who you assisted you. My advice will be to look up a litigation attorney and let them start with proper proceedings with claiming back the 200,000 or claiming the 200,000.
So,
Yeah.
you were the conveyancing attorney, your practice. So
Yeah. My
you don't
advice
do
would
it.
be, we don't do litigation. That's a specialized field. My advice will be to go to another attorney. I can give it to you now, an attorney, or email me and I will send you the attorney that I normally refer clients to's details.
Okay, thanks so much. Appreciate that.
Tahira, will a copy of the presentation be available electronically? Yes, Tahira, it will be. Please request Charlene for a copy of that as well. Can I go back to Charlene's email? There's her email address. Can you guys see it? It's Charlene at janljordaan.co.za. All right. Thank you, everybody. Enjoy the rest of your day and hopefully we'll chat soon. Thank you. Bye-bye.